Welcome everyone to this first NIJAC online information event. Our intention is to create awareness of the judicial offices which NIJAC has recently or is about to advertise, and provide all those interested with greater insight into those individual roles and also the processes of application for which apply to each of those roles. We're going to hear today from people who have been through those processes and have a similar experience to everyone else regarding going through the process and making an application and preparing for the assessment. We hope that those individuals who are Mr. Justice Schofield, Mr. Justice Humphreys, Master Harvey, District Judges Harmer and Logue, and we'll also hear from two NIJAC commissioners, Bernard Brady KC and Michael Robinson, who hopefully will give you a bit more of an insight into the kind of things that the assessors themselves are looking for whenever you make your application and through the assessment process itself.
Good evening, everyone. I've been asked just to talk about sort of two distinct areas associated with judicial appointments generally, and I suppose more specifically in relation to the High Court competition that's coming up. The first part of that relates to your preparation for an application, what to expect, and how to go about gathering the necessary evidence that you'll need to substantiate your application. And the second thing I want to talk about is just some of my recent experience as an NIJAC commissioner and some of the things we learned, particularly through the recent county court competition, which had a very large pool of candidates and which proved to be a pretty successful competition. And there was some good practical experience I think I picked up from being on the other side of the fence in that particular scenario. Anybody who's on this call clearly has an interest in applying for judicial office, and that interest might be simply to have a look at this webinar and quickly switch off the computer and forget about it. Others might have a very committed view that this is a career path they want to be on, and I'm conscious that in between those two extremes there'll be lots of people at slightly different stages of their consideration of this possibility. And one thing I would say is that it is good to take time to consider, first of all, whether it's really a career that you want to pursue, and secondly, whether it's a competition that you want to enter into, because I think you need to be committed to both of those. I think it's not something you can do just to have a look. It's not something you just dip your toe into. There does need to be a recognition that the competitions are robust, they're time consuming, and they're challenging. And all of that has to be recognized. And anybody who's been through perhaps multiple competitions often talks about that, about how maybe the second or third time they did it, they realized actually how much more time and dedication was required into putting the application together than they'd rated the first time around. So it's good to get that in your head quickly. I think one of the things you have to do at the outset is try to assess yourself against the criteria and competencies that the competition calls for. So early on, ask yourself questions: will I be able to meet those standards in different ways? And if so, if I believe I am, how do I evidence it? And the way that the process works with the statement of suitability in the High Court competition, together with 3 pieces of written work, is your opportunity on paper to convey why it is you meet the criteria, competencies that NIJAC are looking for. And those are very familiar by now to everyone. The 2 separate areas, skills and attributes on one hand, behaviour and experiences on the other. So classic legal skills of judgment and knowledge, intellectual capacity being tested in the first one, and the broader skills, of leadership, of collaboration and so on being tested, and communication in the second. But when you're carrying out the piece of self-analysis, identifying what examples you're going to use to demonstrate each of those competencies is absolutely key. There is nothing in NIJAC for reputation. You get no points for having apparently appeared in some great case or advised some client in some massive dispute. None of that counts. Everyone starts on a blank page and you have to demonstrate. And I think that is sometimes, even for the better candidates, slightly lost in the overall scheme of things, that it's really up to you to demonstrate through your answers and the statement of suitability and the written work as to how those necessary attributes can be shown. One of the things I'm often asked is, how do you choose the 3 pieces of written work? Because the statements of suitability might result in fairly well prepared answers. Everyone knows the buzzwords, what's been looked for, but the pieces of written work are slightly more abstract. And my thinking on that is that they don't need to be, skeleton arguments for the Supreme Court. You don't need to demonstrate that if you have one of those, by the way, it will be quite useful, but you don't necessarily need to have the very top end of sort of legal submissions. But what you are trying to do, I think, is demonstrate in each piece of written work a multitude of the competencies that are being tested. So the best examples will be ones where there was a, say, large array of material of a complex nature that had to be assimilated and summarized. That's a very good starting point because it's a key judicial skill. The next thing would be application of legal principles, which again demonstrates knowledge and intellectual capacity to that material. And the third is communication, how well and coherently you could present your advice or your answer to the particular problem that you were dealing with. And I think sometimes on the 3 pieces of written work, some diversity in each is good because you might be addressing a different audience with each. So a skeleton argument targeting a judge or a court of appeal with a high-end legal argument to try and convince a court of the correctness of your argument is obviously a good example, but so is a piece of advice to a client in a difficult, complex case where you're trying to explain to a layperson, a business perhaps, or an employer, someone in a family dispute, could be any client, bringing difficult legal principles to a level and to a language they can properly comprehend. Again, sometimes overlooked, I think, in the overall scheme of legal skills. And perhaps the third type, if you have one, is actually a decision or a judgment that you've reached in a different environment. So if you've sat part-time as a judge or in a tribunal, or indeed any other environment where you've been asked to rule on a particular dispute, I think that demonstrates a different skill again of weighing up competing arguments, finding an answer and communicating it. So diversity in the approach I really recommend because it gives you a chance to sweep across all those skills. And when the panel's carrying out its shortlisting, it will look at those and really will examine how and by what means each of those have been demonstrated. And those who demonstrate them all will be shortlisted. If you're short on any one of the competencies, then you won't be. And it doesn't matter how brilliant you might appear intellectually. If there's nothing that you're demonstrating, your collaboration or your teamwork, your leadership skills, then you'll fall short there and won't make it over the line. And that is a situation we've had before. In terms of the experience we had in the county court competition, that was very much it. That it wasn't necessarily the very best people who scored the best, particularly at the shortlisting stage. It was those who chose their examples well, who were able to articulate why their examples were doing what they said. Some of the better candidates I found assumed a certain degree of knowledge, took it as a position that they would know what I mean, when in fact we can't assume anything at that stage. And perhaps the most important piece of the jigsaw when it came to the county court competition were the situational judgment and role play exercises which we engaged with at the interview stage. Those are more difficult to prepare for, but in fact, I think when you go through the exercise of identifying your own skills and addressing them on paper, it does provide you with a platform to understand what are they looking for in a situational judgment or a role play. What people aren't looking for is are right answers. There are no right and wrong answers. What I think we're looking for particularly is clarity, clarity of thought and of communication, of calmness and of coherence in presentation. So a lot of value is gained from seeing a person put their skills that they evidently have into operation. We all recognize that it's not the real world. It's a fictitious environment, but it's also a very valuable one, to give you an opportunity to stand out, to articulate in a way a judge would in a courtroom, how you would deal with a legal problem or how you would deal with people in a certain scenario. And I know each of these competitions will be different in the way in which those interviews are conducted, and different ways of testing skills will be engaged. But certainly in the High Court one, I think the situational judgment piece will be absolutely central to the final selection process. And it's perhaps understandable that people have a uncertainty around that. And that's the way it's designed to be, though. The lack of preparation time, having to do something quickly in a perhaps an unfamiliar environment, is again a key skill that the judiciary require. And so it's perfectly normal to have a feeling of lack of control and lack of insight into what's required there, because that's what it's designed to be testing, is that unfamiliar situation. But my overall take on the competition I was involved in was that the best candidates did shine through. Those who were appointable had, I think, a combination of all the skills demonstrated. And when you sit back at the end of a competition, you do take a holistic view of everything that comes in on paper and of everything you see in an interview and everything you hear in a presentation or a role play or situational judgment. And the whole picture can then be analysed. So if you feel as if you didn't maybe perform as well as you might have done in a situational judgment, that's certainly not determinative, because it is a whole picture we're looking at. I think that's one of the ways in which NIJAC has improved its appointment procedure. The statement of suitability and the holistic approach to the skills, I think, has benefited the better candidates in coming forward. So those are my initial thoughts on the approach. There will be, I'm sure, formal avenues to approach members of the judiciary during the course of the competition. But certainly my door's always open. If anybody wants to come and have a chat about what to expect or whether to put their head above the parapet on this occasion, I'm very happy to talk in complete confidence, of course.
Sorry, you can't see me. And I know I can't see you, so I hope you find this valuable, even though it's a slightly disembodied experience. For those who don't know me, my name's David Schofield. I'm a High Court judge here in Belfast, and I was appointed on a full-time basis in November 2020. So I've been performing my current role for just over 5 years now, and before that I was at the bar for 21 years. I've been asked to give some perspective on the role of High Court judge, on how it differs from practice, and to say something about the application process, which I'll do, but which will be more brief than what my colleague Mr. Justice Humphreys has said in relation to the process itself. So a disclaimer first, when the forthcoming High Court vacancy comes to be advertised shortly, there will of course be helpful documentation available within the applicant information booklet, which will give you a detailed picture of the role of High Court judge, and that will include a job description amongst other things, and I would urge you to study that closely. There are also, if you're interested, a number of judicial bios on the NIJAC website for current High Court judges, which I would also commend to you as further recommended reading. So what you're going to hear from me now is my own personal perspective. Now, if you've dialed in, I'm sure most of you will know that aside from judges of the Court of Appeal and the Lady Chief Justice, High Court judges are the most senior judges who sit in Northern Ireland, and they exercise the extensive jurisdiction of the High Court in all its aspects. So the first thing that I want to say is that the role is extremely varied. So although you're assigned to a particular division, which will provide the mainstay of your day-to-day business. You're expected to assist with a range of the High Court's work. So your division may or may not reflect the type of work that you've undertaken in legal practice. All High Court judges also have to frequently deal with bail applications, with applications for leave to appeal to the Court of Appeal in criminal cases. And we also undertake certain work in the Crown Court from time to time, trying serious criminal cases with juries. So the role spans the civil and criminal divide and the full span of civil work. Additionally, you can be asked at any time to assist with cases where a judge is required. So, for example, if there are a number of running civil actions on a particular day in the King's Bench list, or if another judge needs cover for some reason. All High Court judges are also expected to be the duty judge on several weeks of the year and during holiday periods, in which case you can be confronted with all kinds of emergency applications, urgent judicial reviews, applications for declaratory relief in relation to minors or patients and so on. And in recent times, you've also all been asked to act as coroners to assist with legacy inquests. So the role is well suited to people who enjoy variety, to people who are interested in the law, and to people who are prepared to take on new challenges and apply their skills in a number of different areas. So do not assume that you will simply be doing the type of law that you're doing now if you apply successfully. And that is one of the challenges, but also one of the exciting and interesting aspects of the job. The second thing I'll say is that the job is demanding. And let me deal with two aspects to that. Firstly, the workload, and then secondly, the responsibility of the office. There are advantages to life as a judge, but you certainly shouldn't apply to the High Court for an easy life. In all divisions, you'll find that the workload is pretty heavy to a greater or lesser degree. So if you imagine the number of lawyers and litigants and experts and witnesses involved in any case, they're all beavering away, producing input, which will ultimately arrive with you sitting alone for consideration and resolution. And then if you multiply that by the number of cases on your lists at any one time, you can imagine how that can sometimes feel pretty daunting. And one of the greatest challenges, I think, is time management. Finding the time to reflect upon and decide concluded cases at the same time as preparing for future or imminent hearings and dealing with urgent issues or applications which arise unexpectedly. And as well, all High Court judges are expected to undertake some extrajudicial roles. So that could be representing the judiciary, chairing committees, giving talks and lectures, and all of that adds to the workload. So you do have to be prepared to work hard. And the other aspect of the demands of the role, which I mentioned, is that of responsibility. So as a High Court judge, you're obviously making important decisions about people's lives, perhaps with significant financial effects, but often with even more far-reaching implications affecting people's livelihood, their home, their family life, or even their liberty. Now, I personally don't find that overwhelming, and I think there is a healthy element of detachment in the way that we work. But I know it is something that can be a source of pressure because you obviously want, as far as you can, to make decisions which are the right decisions and just decisions. And a significant part of that responsibility, I think, is also a need for a high degree of patience and level-headedness. So very often cases which you think should resolve don't. And sometimes counsel and increasingly litigants in person can run points or repeat points or unnecessarily labour points which you feel are going nowhere. But a key part of the job, of course, is to make sure that everyone is given and feels that they've been given a fair and proper hearing. And that can be demanding in itself, especially when there are other pressures on your time. And I think there's also a pretty clear trend of cases becoming much more paper heavy in recent years. So there is a lot of reading involved. I don't want to be overly negative, however. I'll be in trouble with the Lady Chief Justice if there are no applications for the next High Court appointment. So let me also say that the job is incredibly rewarding. It may sound glib to say this, but there is a real sense of public service amongst the High Court bench. You do feel that you're making a difference to people's lives in both big and small cases. You do feel that you're upholding the rule of law. You do feel that you're administering justice on behalf of the community and serving the community, even when some or all of the parties in the case might not see it that way. And I think if you're considering applying for the role, that has to be something that motivates you. It's by no means as glamorous or exciting as it might seem from the outside, but it is a role with a very particular type of job satisfaction. And if I might say so, I think there's also a very good working relationship between all of the judges on the High Court bench at the moment, and there's a pretty good team spirit with colleagues who are always willing to offer help if you need it. So those are some thoughts on the role. How does it differ from practice then? And I suppose that depends really on what your current practice is. My own experience was coming from the senior bar, so that's what I'm going to focus on. And there were 4 thoughts that occurred to me that I thought I'd mention. First, a key element of the role is independence. So notwithstanding what I said a moment ago about team spirit, aside from the limited occasions when you sit as part of the Court of Appeal, and leaving aside the support staff who work in the court offices who are all very helpful, you are generally working on your own. And if you come from the independent bar, I think that's less of a shock to the system than it is to those who've come from some other backgrounds. But even for senior barristers, there is a shift from working as part of a team back to working very much on your own for most of the time. So that's something to be aware of. Second, if you've been self-employed and you're used to picking and choosing the cases in which you act to some degree, there is a certain shift in culture when you become a judge, and you're obviously a public servant. So you're not an employee, you're not bound to be in the office or in court 9 to 5 every day, but you are generally expected to be available, to be working and to be sitting during term time. And you're also liable to be assigned to cases or to roles by the Chief Justice, which you might not yourself choose to undertake. So in that way, you're not quite the master or mistress of your own destiny that you may be when you're self-employed. But third, and this is maybe counterintuitive, I think there is a kind of liberation moving from the bar to the bench. In this respect, I think you'll find that your phone will rarely ever ring with a work-related call, and even more rarely so on evenings and weekends and holidays. So you're no longer incessantly chased by and expected to be available to clients or solicitors at all times of the day or night or week or year. So there is definitely some measure of escape from the oppression of the mobile and the tyranny of the email. And that's, I think, one of the main advantages over practice. You're very much more in control of your time and scheduling than when in busy independent practice. And fourth, and I think this is a factor which people often don't consider enough, given the nature of the role, there are extremely high standards of conduct and impartiality which are expected from you, which I think some people can find inhibiting, for instance, in relation to their social life or their activities on social media. And you'll also find that some people, including people that you knew well professionally, will sometimes treat you a bit differently. So I do think you need to be prepared for that. I think my time's running out, so let me just finally say something about the application process. And again, that's not so much about the detail, but my overarching advice is this. If you want to do the job and you think that you have the qualities to be good at the job, do not let the application process put you off. Is it enjoyable? No, it's not. Will you welcome being interviewed, perhaps by people that you know well for a job? Also, probably not. Does it come naturally to you to tell everyone how amazing you are? Hopefully not, if you're applying to be a judge. But my point, which I think Mr. Justice Humphreys has already made, is that NIJAC does need to have a robust, objective, independent process to test candidates' qualities for the role of High Court judge. And if you think you would make a good High Court judge, and if you still want to do it in light of all that I've said, then please don't let the application process put you off. as I've said, my experience of it was that it wasn't as bad as I feared. It wasn't a particularly enjoyable process. I think most people come out of it thinking that they haven't done themselves justice, even if they have done well. There's also always a risk that people might find out that you've applied, although, as Andrea's mentioned, the process is strictly confidential, but you will find that people might ask you outright about whether you've applied for a judicial post, and that can give rise to awkward conversations. In my view, honesty is the best policy in those circumstances, but that's obviously a matter for individual applicants. But I just want to emphasise the process is worth undertaking if you want to do the role. You just have to accept that it's a necessity. You should prepare, obviously, as carefully and conscientiously as you can, and then you just have to put aside whatever modesty and embarrassment you have and get on with it. So in summary, just like the job itself, the application process will involve things you're not used to. It will be demanding, but it will be rewarding if you succeed when you come at the other end. The other thing I wanted to say was, if you don't succeed, but you'd still like to apply again, you really just have to dust yourself off, put it down to experience, treat it as a learning opportunity, and go again the next time. So I hope that's been helpful. For those of you who do decide that you want to apply, I wish you all the best. As Mr. Justice Humphreys said, I'm more than happy to speak to anyone who wants some further advice about the application process or about the role, and I'd be very welcome to talk, or I'd be very grateful or happy to talk to you in confidence. So thank you very much for listening.
Right, good evening, everyone. For those who don't know me, my name is Mark Harvey. I go by the rather antiquated title Master Harvey. I also have similar issues with the video, but given I have a face for radio, maybe that's for the best. This brief talk will be a mix of the personal and the practical, and I will talk about three things. Firstly, my experience since appointment as a Master of the High Court. Secondly, the role of Master more generally, and thirdly, lessons from the selection process based on my experience. I was sworn in on the 21st of September 22. I vividly remember that day. It was lovely having so many friends and family there. Then the next morning, a novel thing happened where for the first time in my career, someone came and handed me all my work for the day, consisting of 43 clinical negligence cases for review. My first list is framed and hangs on the wall of my chambers. It can be disorientating going from being a practitioner one day and the next sitting robed in the judge's chair staring out at faces you perhaps work with or had cases against. I feel privileged though and proud to be in this job. If you want a sense of purpose and to be in a role where you can make a real difference, the judiciary is a great place for you. And I echo Mr. Justice Schofield's comments regarding the positives of public service. NIJAC are brilliant throughout the process, and I always remember that before being officially sworn in, the Chief Executive of NIJAC, Tanya McCormick, invited me for a meeting, which is her custom. The warmth she showed me and the sound advice she offered in that conversation put me at ease and left a lasting impression. She talked about judiciary often having an imposter syndrome, and how if you ever have a bad day, to keep all the well wishes you received in cards and messages on being appointed and have a look at them if you need a lift. I kept them all in a box, which is still in my cupboard in chambers, and after 3 years, I'm glad to say that fortunately, I haven't had to open it. If it's feedback you want, this isn't the job for you. You won't have the parties tell you how brilliant your judgment was. The best you can hope for is that they feel confident you will hear all the arguments, you know and will apply the relevant legal principles, deal with the case fairly, and give a prompt decision which is clearly communicated so the parties, and more particularly the losing party, understand the reasons for your decision. In this job, no 2 days are the same and the workload is heavy. One thing you quickly discover is that the role is so much more than what appears in the court list, which represents a fraction of the actual day job. As King's Bench Master, I have a court sitting each day of the week, from hearings to reviews and summons court. The intellectual challenges in court are enjoyable, and there's the need to problem solve on a daily basis with technical legal points and issues arising in any case, meaning you must stay sharp. 99% of all the cases I hear are dealt with on the day with an extempore decision. There may be the need for written judgment in a small number of complex cases. This is time consuming, and being from a solicitor background, it was frankly new territory. And while at the outset it was quite daunting, it has become another enjoyable aspect of the job. and such judgments are an invaluable resource when delivering lectures to practitioners, which I often do. Away from court sittings, just like being in private practice, the emails are voluminous, with various applications and requests from legal representatives and other matters requiring my attention. There's also a large volume of applications and matters to deal with on the papers, and I sit on a variety of 7 different committees, some of which I chair. While at times the demands can be considerable, the control you have over your diary and the listing of cases helps if, like me, you have a young family. Management skills are vital in the job, as my role is in an extremely busy environment and you do need to be proficient in IT, as you will be doing all your own typing. You can be the best lawyer in the world, but if you don't have a business-like approach to judicial case management, things won't run efficiently or effectively. While you have no staff management responsibilities, teamwork is vital and you must work collaboratively with colleagues and the court staff. Overall, I found the job is even more varied than I imagined. You inevitably have to learn as you go and develop your knowledge and experience, and every day is a school day, no matter what stage you're at in your career. I recall before taking up post someone telling me that being a judge is isolating and lonely. While judicial office holders are independent and all your decisions are no one else's but your own, I've found the atmosphere is very collegiate. Masters, for example, meet for lunch regularly, which is a combination of social and business. I've also found the presiding master and the office of the Lady Chief Justice very supportive, and there's a genuine focus on judicial well-being. Turning to the role of a master more generally, there are 7 full-time masters in the High Court, and historically they've been appointed to specific posts which are unique and have very different demands in terms of the jurisdiction exercised and the nature of the work. However, masters to varying degrees are regularly required to sit in divisions of the High Court other than that to which they're assigned, meaning they must adapt to the different systems in operation and the different law applicable. Hence, it is important to attend CPD and keep abreast of legal developments across other areas of law. And in this regard, we all get a weekly library update of judgments and cases and a daily media circular, which together with the Judicial Hub and frequent Judicial Studies Board events are invaluable. Masters sit on the liaison committees associated with the division to which they're assigned, and some of us also sit in a wide range of committees, including the Shadow Civil Justice Council, Judges Council, and the Judicial Studies Board. The workload is increasingly demanding, and all masters now hear undefended divorce petitions, and some also routinely hear matters which in the past would have been referred to a judge of the High Court, with the result that there's greater emphasis on the writing of judgments, which often must be done outside normal working hours. Turning briefly to the forthcoming vacancy for Master Care and Protection. This is due to be advertised in early 2026. The OCP Master hears applications involving children, such as wardship applications and applications in relation to patients, for example, appointing controllers and approving statutory wills, as well as general matters relating to the property and affairs of patients. Frequently, the monetary value of a patient's financial affairs can be very significant and involve complex legal issues. Contested hearings can be lengthy. For anyone interested, you can keep an eye out on NIJAC forthcoming vacancy announcements. The final thing to say about masters generally is that the terms and conditions for masters posts are excellent with regard to remuneration, leave and the pension. From a pastoral perspective, I've found it to be a very supportive environment in the event of illness or unforeseen life events. Our tier doesn't have any security arrangements, meaning it is a more discreet role and it's easier to fly under the radar of your neighbours as you won't have CPU sitting outside in the morning. One of the other big advantages is that we're based in the Royal Courts of Justice in the centre of Belfast. You get a parking space and plush chambers which even boast an ensuite. What more could you ask for? Finally, I'll talk about lessons from preparation for the application process itself. Firstly, the application form. Look, I appreciate everyone will have their own approach to this, but I always find that before starting the form, the first step is to take a blank A4 page and set out a short summary of the things you've done in your career, the roles you've held, the complex cases you've worked on, difficult situations or advices you've dealt with. It serves to refresh your memory and gives you a confidence boost, because pretty soon you'll have built up a list of really useful examples, drawing on your experiences, and will often include things you probably forgot about. In preparation for this event this evening, I had a look back at my form for when I applied for this job, and a few things occurred to me. There's a word limit of around 500 words per question on the form, and it is vitally important you break down the criteria into chunks and answer each part. Each competency might have a headline topic, such as in my form, intellectual capacity, knowledge, and expertise. But within this, you're expected to deal with the various subcategories, which in my form, if analysed correctly, had 9 separate areas, and you need to address each. This ranged from legal expertise and the ability to deal with complex problems, and the ability to master unfamiliar areas of law. I recommend drafting your answers in a separate Word document. Do a word count and then copy this into the form, but be very wary of formatting issues. Examples must be provided, and I cannot emphasize enough how you should not dwell on the nature of the example you're providing. It should not take more than a sentence, but it must have weight, sufficient complexity, and be relevant to the criterion and relevant to the qualities you'll need in the role. The formula for the use of examples has been given different acronyms, such as STAR. In essence, what this means is you must briefly describe the context for the situation or example, then specifically set out what you did with the emphasis on you, and finally, what the outcome was. You may also wish to refer to what you learned as a result and looking back what you might have done differently. That type of self-reflection, learning from one's mistakes, could be something you're asked about at interview. Bear in mind the forms are anonymised, and a word of caution, do not use examples in your form that you would not be confident to talk about at interview. Frankly, you often may be able to guess the level of experience of your competition in the process and ask yourself, what have you done that makes you stand out? To borrow the phrase, what is your USP? Once the form is complete, revisit that A4 page I told you about at the start and ask yourself, have I got everything in? As I said, be very careful of formatting issues. The narrative in your form should not read like a stream of consciousness essay with no punctuation, poor grammar, and isn't broke up in a way that makes it easier for the reader. In this regard, bullet points can be useful. If you make it past shortlisting, you then move on to the interview itself. The process for my post lasted 2.5 hours and involved 3 stages: a situational judgment, an interview, and a role play. At the start, I was given a 5-minute briefing, then handed a lengthy situational judgment with a scenario involving a commercial litigation dispute with a series of technical legal questions at the end. I was allowed 30 minutes prep time. The panel then asked questions about this scenario for around 10 to 15 minutes. The interview immediately followed and lasted approximately 45 minutes, with 6 or 7 questions from the panel. I was then given a 5-minute break and was provided with a role-play set of papers to read for 20 minutes. What followed was a court-based scenario where there were actors playing the parties in a hearing. I had to play the role of the High Court Master. This lasted 30 minutes. One piece of advice I would give is don't make my mistake and go back to work after it. It is a very draining process. So whatever role you apply for, the process may differ. I have to say the NIJAC staff do a fantastic job and they provide you with a wealth of material in advance which will assist you. And if you look at their online resources, you should have no shortage of information. I encourage you to read any talks or judgments by the predecessor in the job you're applying for. At the assessment, for example, I had a complicated situational judgment, but some of the legal issues had been traversed in a commercial case I'd read from 2014 and a judgment by my predecessor. Another tip is that the Equal Treatment Bench Book was a really invaluable resource, and I had read extracts from this which helped with the role play scenario on the day, as it involved an actor who was playing the role of a personal litigant. As it turned out in King's Bench here in the High Court, I will often be the personal litigant's first judicial encounter, as civil procedure issues often arise, so this has actually proven useful in real life also. Finally, there are apparently people out there who offer paid advice and support with selection processes. This is a matter of individual choice, as Mr. Justice Schofield alluded to as well. I'm strongly of the view you need to be genuine and authentic in your answers in interview. From my perspective, I opted to go it alone, and a bit like doing the driving test, I didn't tell anyone I'd applied and I didn't seek advice. I think there is a danger in using such services that candidates might provide robotic and formulaic answers. And while I urge caution, I'm certainly not saying you shouldn't seek advice, as it is out there in abundance, especially if you're not familiar with the format for public sector competitions. Personally, I found the material NIJAC provided sufficed. But there are other options such as judicial shadowing, albeit not of course for a live competition, and speaking with a named contact for the relevant tier. The last thing I want to say is this: the recruitment process is daunting, but regrettably, there are many highly talented practitioners out there who exhibit sound judgment and common sense, but who sell themselves short and think such roles are beyond them, meaning they're afraid to apply. My advice is quite simple. If you're capable of doing the job, remember the selection process is a level playing field. Do your best, don't sell yourself short, and remember, it's okay to be afraid, but do it anyway. You might find you thrive in the judiciary. Thank you all for listening, and if you do apply for a post, I wish you well, and as indicated as well by my colleagues earlier, I'd be happy to talk to anyone in confidence should they wish. Thank you.
Thank you. Good evening, everyone. Thanks, Mark. For those of you unfamiliar with the District Judges Court, I was appointed in January 2022 as a District Judge, and I'm sharing this slot with my colleague Catherine Logue. The District Judges competition has been started, and I'm going to be discussing the process, particularly the application form, and then giving you a broad outline of the role of a District Judge before passing on to Catherine. So the first stage is the application form, and although it sounds basic and perhaps a little like preaching to the choir, but do not underestimate the importance of the application form. Completing the personal profile is not a task which can be done overnight. It will require time to identify the examples which best fit each of the criteria or competencies. At this level of the judicial family, many candidates wrongly assume that their reputation as a solicitor or barrister will be sufficient to pass this first hurdle, or giving general examples of the work conducted or high-profile judgments they've been involved in will suffice, but it will not. You must read the material that comes with the application form. It is key. You will get good guidance from the application information booklet and the guidance for applicants document. There are 6 separate competencies, and they are broadly broken down into 2 categories. The first 3 are knowledge and expertise, intellectual capacity, and exercising judgment. And you will quickly identify that these are testing your ability to deal with the technical and legal aspects of the role of a district judge. The other 3 categories are collaborating, communicating, and managing effectively. And these are testing you on whether you have the personal qualities to do the job. You must demonstrate your ability in each individual area. Some aspects of the application will be easy to meet, but others will be more difficult or challenging. My best advice is to avoid legal jargon if possible. The panel will have to shift a large number of applications, and you want the 3 panel members, including the lay member, to easily identify how your examples match the criteria. Remember that your examples can come from roles outside your legal work, as has already been mentioned by Mr. Justice Humphreys. I'm sure many of you sit on various boards, such as Board of Governors of Schools, charities, or statutory boards. Remember to draw examples from this work, particularly if you're the legal chair of a board or you have conducted oral hearings. I utilised an example from my role in the Board of Governors of my local primary school for one of the criteria, and overall it demonstrates a broader range of skills and diversity. One of the most challenging aspects of this application is the low word count. Lawyers are not known for being concise. Each competency is limited to 500 words, and it is difficult to demonstrate how you meet the criteria in such low word count. Each of the 6 competencies then has individual criteria to meet within each one. If you take the example of knowledge and expertise, you must demonstrate within that competency a commitment to access to justice and the rule of law. You must demonstrate integrity, objectivity, and independence of mind, and how you've reached clear, reasoned decisions, advices, or opinions based on facts. Try to avoid using one example for all 3 criteria. If possible, use 3 separate examples and avoid using the same example twice, even for a different competency. Candidates who utilise different examples for each individual criteria tend to score higher. If you opt for this method, you can see immediately how taking time is important, as that is up to 18 different examples that you will require to complete the application form. Given your background, you will have numerous examples of interactions with legally qualified colleagues or with the judiciary, but you should demonstrate knowledge or give examples of assisting vulnerable individuals or how you have interacted with litigants in person. This is undoubtedly relevant to all tiers of the judiciary, but particularly relevant to the work of a district judge, where there are a larger number of participants who are self-representing in the small claims court and dealing with ancillary relief applications. You do need to research and be familiar with the role of the district judge, but please do not be concerned if your day-to-day life is not in this court. It can be in other courts or primarily office-based. Your current role will undoubtedly have transferable skills which you can easily use to meet the criteria. I had limited exposure to work in the county court before I was appointed, but I was able to match the criteria to the work I conducted in the High Court, Crown Court and Coroner's Court. You probably won't have time, given that this competition is opened, to attend formal judicial shadowing, but it is worthwhile attending a court and observing a typical list for a district judge. I would also recommend that you make contact with the nominated representative. That's myself for this competition. I find this really beneficial because not only can you ask about the application form, but you can also ask more practical questions which are relevant to your personal circumstances and your assessment of whether this role is right for you. Remember that the application form is an important part of the final stage of the process as well, which Catherine is going to discuss in more detail. You have a limited word count in the application form, but you are likely to be asked to expand on these examples that you have given at interview. So you must be able to talk about them in good detail. Overall, my advice for the application process is good preparation. It will take many drafts, but do not let that deter you. I turn now to the role of the district judge, and there are four full-time salaried district judges spread over several divisions. The presiding district judge, Judge Duncan, sits in Laganside. The other three roles are peripatetic, and we each sit in two courts. The work is allocated with Judge Logue in Antrim and Derry, Judge Collins in Newtownards and Lisburn, and I sit in Omagh and Armagh. It is only after you're appointed that you will know which of these courts you will be allocated to. Generally, we split the working week between the two courts that we sit in. This requires a lot of pre-planning and organisation to ensure that you are well prepared for each court day and you have time to review your cases, in all cases in your list in advance of listing. I worked as a solicitor prior to appointment in a large corporate firm managing a team of other lawyers, and one of the biggest challenges I faced on appointment was the change to solely managing my own workload. There's no secretarial support or bank of junior lawyers or paralegals to assist. If only I could have brought my very efficient secretary along with me, it would have made my job a lot easier. Those of you at the bar may find the transition a little easier than solicitors coming from private practice. The job description in the information booklet is an accurate reflection of the work of a district judge. The work is very varied, and a typical week can include several days of civil lists, a small claims court, and a list of ancillary relief applications. A typical civil list will include HP and ejectment applications, contested interlocutory applications, and up to 10 to 12 civil bills listed for hearing. If you succeed, you will be concurrently appointed as a Deputy County Court Judge, which adds an extra and interesting dimension to the role. In a typical month, you can be allocated more sittings as a Deputy County Court Judge than a District Judge, and this work will involve undefended divorces, higher value civil claims, equity civil bills, and statutory appeals. And it's definitely this work that keeps me interested and pushes me to grow. In addition to the court work, each working day will include administrative work or box work, as it's sometimes referred to. As Master Harvey has said, it's not all about court work. And every day in chambers, you will deal with interlocutory applications, the signing of decree absolutes, taxation of costs, queries from parties in cases that may be in your list in the future or have been in your list, and case management of future lists and cases. There's also regular, if not daily, contact with the other judges in this tier as we discuss listing issues, updates in particular cases, or developments from our committee work. The district judges tier is small but very collegiate and friendly, and I've had brilliant support from my colleagues on the district judges bench. I'm conscious that I'm not taking my own advice and not being concise, and therefore it's time for me shortly to pass over to Cathy. But in my view, the most important attribute of a district judge is good decision making in a past-based environment. If you possess this skill, then you will thrive in this role. I enjoyed my work as a solicitor and I did love the firm I worked in, so it was a big decision for me to apply and accept this appointment. And whilst I do on some occasions miss the buzz of a busy office, the last 4 years as a district judge have been very challenging, but mostly very rewarding, and I highly recommend the role. It's great to see so many people who have registered their interest in attending this seminar today, and I do wish you all good luck with your application.
Thank you very much indeed, Claire. I'm Catherine Logue and I was appointed a district judge in April 2021. I've been asked to speak about my perspective on the role as district judge, how to prepare for assessment, and what I see differently about the skills required now that I have been appointed. I want to say firstly, it is a very enjoyable role, but I cannot emphasise enough that you must be prepared to work hard. I do get the impression sometimes from practitioners that they think appointment to judicial office is a pathway to a lighter workload. It is not, and that's irrespective of what tier you aspire to join. As regards the work of a district judge, please do not assume that because the monetary jurisdiction is lower than in other tiers, that the work will be easy. The district judge court is fast-paced and the lists are very busy. The variety of the work of the district judge means that no 2 days are the same. I remember with the information pack in relation to the role before I applied for district judge, it said in that every week you will come across something completely new. And I thought that was an exaggeration, but it is not at all. As I say, it's a very wide jurisdiction, and I think some people fail to appreciate that. And it's so important to research the role before you complete your application form, particularly when you're thinking of the examples that you're going to give in your form, and try to tie it to the work that the district judge will do. In the beginning, it can be challenging adapting to your new role while simultaneously coming across novel cases or issues to be dealt with. But it keeps the job interesting, and as I say, it is very rewarding. In my professional career, I acted predominantly in personal injury cases, employment law cases, and contract law disputes, and that was good preparation for the work of a district judge. But please bear in mind that the district judges deal with a vast array of cases. For those of you who are family law practitioners, please have confidence that your experience counts. District judges hear all the ancillary relief cases in the county court, and there are many cases which are complex, and your experience of family law will be of enormous assistance. Also remember that the skills you have honed as a family law practitioner translate well into the work of a district judge, such as dealing with people in crisis, explaining law and procedure in plain English, understanding financial information, and working towards pragmatic solutions. It's important that everyone should note that upon appointment as a district judge, you're concurrently appointed as a deputy county court judge. And as Judge Harmer has said, at the moment, the majority of our work actually is as deputy county court judges. It's very varied also. The work includes divorces, civil litigation, equity cases, and statutory appeals. We're a small tier with only 4 judges, so there are lots of opportunities to become involved in committee work, which adds another dimension to the role. In some ways, regards my perspective on the role, I would say you need to have a really good work ethic. Don't expect to have a lighter workload. Do not feel that you should not apply because you lack experience in some areas of the job. What you need is aptitude. And please do not be daunted by the unknown. Everyone learns on the job, but of course you must be prepared to put the effort in. In terms of how to prepare for the assessment, it's vital that you appreciate that, as with any assessment, the aim is to evaluate your suitability for the role. It is really worthwhile, as Judge Harmer said, to have a conversation with her as point of contact. Carefully consider any information you're given in advance of the assessment, such as the job description and the nature of the role documents within the application pack, and how you can match your examples to those. It's, as I say, the district judge jurisdiction is very wide, and it's really worthwhile researching those aspects that you're not particularly familiar with. As I say, don't let that deter you, but bear in mind that the assessment, you may be asked about areas that aren't really within your field of knowledge in your normal working day-to-day life, but you are expected to have a working knowledge of relevant procedures and an awareness of the issues and cases that district judges come across each day. Think of the type of questions you may be asked at interview and how you would respond to those. I wouldn't expect anybody to learn their answers or have some set formula for an answer, but try to anticipate the sort of questions that you're going to be asked and try to think how you can match that to the criteria in terms of the information that you're going to give to the interview panel. Know your form and the examples that you've given for each area of the competency that are being asked for. I would say it would be very valuable if you come along and observe some work in the district judge's court, go to various courts maybe on different days when there may be different types of lists, just to see how those cases are managed in court in terms of directions hearings and ultimately how the cases are dealt with. I would say it can be a very daunting prospect applying for any judicial role, but please have faith in yourself. The only way you can be sure that you're not going to get appointed is if you don't apply. And I do know from personal experience how exposed you can feel during the process, but don't be put off by the thought that you think other people have applied who maybe have what you consider to be stellar CVs or have acted in very high profile cases. The system is designed to test competency. It examines whether you have the skills for the role, and you can display this in the examples you give and how you perform during the assessment and at interview. Turning to what I see differently about the skills required now that I have been appointed. I was familiar with the general court-facing role of a district judge through my professional career as a solicitor and then a barrister, but I think the importance of resilience and adaptability cannot be overemphasised. Other than the presiding judge, you will not be based in just one courthouse. Your division will comprise of 2 venues, and given the regularity with which the district judges sit up as a deputy county court judge, you can often find yourself sitting in multiple venues during the course of your working week, hearing a wide variety of cases. I would say communication skills are key. The ability to adapt your communication style to promote engagement and ensure cases are dealt with efficiently is absolutely vital. The majority of people appearing in the small claims court are litigants in person, and we see increasing numbers of litigants in person in civil cases and in ancillary relief cases. Judge Harmer has already mentioned this issue in respect of administrative support, but I have to say I underestimated the amount of administrative work involved before I was appointed, and I didn't anticipate the very limited administrative support available. I found my IT skills of great benefit in that regard, but I think it would come as a shock to most people how little administrative support district judges have. For those of you who are solicitors, you will have to abandon the comfort of having a secretary or dedicated secretarial staff. The reality for district judges is that you have to prepare all your own file notes, draft orders and directions, as well as literally typing up judgments and reports and so on. For those of you who are barristers, that may be not so much of a culture shock. You're used to preparing your own paperwork and so on, but I think you may find the difference is that the flexibility that you have as an independent barrister is gone, and your work is much more regimented, and I think that's an adjustment you should consider before you apply for the job. But that said, I anticipate that anyone applying for the role is likely to be a diligent, dedicated, hard-working individual. And can I reassure you all that we are a very welcoming tier. I know, and I know I speak for Judge Harmer too, when I say I have found enormous support and collegiality from the members of our tier. And I would encourage as many of you to apply. Please focus on all the skills that you have and what you contribute. Don't hold back thinking about other people who may be applying. Concentrate on what you have to offer for the role. Please don't give in to imposter syndrome, because it will only hold you back. And I'd like to echo everybody else's comments and wish you all the very best with your application. And I look forward to meeting our new district judge in the very near future. Thank you.
I will try and be succinct. I'm one of the two legal commissioners on NIJAC. I was appointed in March 2023 from the Bar of Northern Ireland. What I would say, I've sat on a number of selection committees over that time. I would echo most of the comments that have been made over the past session. I would identify 3 points, if I could, which I think are worthy of particular note. The importance of well-chosen examples. What do I mean by that? Well, NIJAC points on the merit principle. That simply means that the person who is most meritorious at the end of the competition will be the person or persons appointed. It is a robust, evidence-based process, and I know a number of judges have talked about how daunting the process may be. I will say, for my own part, the selection committees do attempt to try and put you at your ease, but they do recognise that nerves and the nature of the process are such that it will be necessarily robust. But in any event, you should read the guidance and the application pack. And be aware that the examples that you choose should be selected to demonstrate each aspect of the required competence. The second point that I would wish to make is the importance of clarity, of a methodical and structured response, and that's important at both the written application and for the shortlisted candidate for those who attend interview. Speaking as somebody who has sat on a selection committee, it certainly does make the task much more straightforward if the evidence which is presented in the written form or at interview in response to the questions takes a methodical and structured route and demonstrates the criteria in that way. The third point, and my final point really, just in relation to the selection process, is don't neglect the soft skills. So the previous contributors this evening have talked about the personal specification and how to separate it into two broad areas, skills and attributes, and behaviour and effectiveness. The skills and attributes are, of course, knowledge and expertise, intellectual capacity and exercising judgment. Behaviour and effectiveness are collaborating effectively, communicating effectively, and managing effectively. You will be presenting to, or you will be being interviewed, and your application will be assessed by a selection panel which comprises legal and lay members and commissioners. And it is important to bear that in mind. So clarity of communication, the ability to provide a detailed and non-technical response, both at interview and in the application form, is key in my opinion. So those would be my very brief observations on the selection process. Michael.
Bernie, thanks very much for that. There's been a very expansive discussion this afternoon about everything, and I'm a bit embarrassed to come in at the end and try and say something that's substantive. But the first thing I would say to everybody online is this, and I want to emphasise this, that NIJAC and the selection committees welcome you into the process. And I know this is a complicated process, and these are very important jobs, and that's why the process is complicated, and so much diligence put into it. Everybody involved in the process, that's NIJAC and the selection committees in front of whom you appear, are all wishing you the best in the process. They're not there to confuse you or to put you off. And so make the application and do your best, and people are pushing for you to do that. The second thing I would say is that, and I think other people have said it this afternoon, it's very important to read very carefully the forms that NIJAC produces. They set out clearly the nature of the role, and sometimes people make assumptions about what they're applying for without actually researching behind that, and either researching through the NIJAC forms or speaking to the point of contact who will be listed in the NIJAC forms, just to make sure. But make sure absolutely that you know what you're applying for, because in doing that, you can then make your application process, and you can make your answers throughout the process job specific, and you can target everything to the job at issue. The applicant information brochure is very detailed. The application form is very detailed, and so I would just stress it's very important to read carefully, to apply whatever you're doing and whatever you're putting on paper to the specific role. Mr. Justice Humphreys earlier, and other people have mentioned the fact that you must demonstrate or evidence that you have the skills at issue. And as someone who sat on a number of interview panels over a number of years, unfortunately, you do see, firstly, at shortlisting stage, because of shortlisting stage, they don't get beyond shortlisting stage interview. You see at shortlisting stage, application forms that come in, and people just state that they have a role, they do this, they do A, B, and C, they've had certain cases, they list the cases. That will not get you anywhere. You must read very carefully the question in the form that you're being asked to answer, and you then must answer that specifically and address those points in a granular way to detail to the people reading the forms that you have the skills that you state that you have, and that you know how to apply those skills, and that you show the people reading the forms or interviewing you that you can apply the skills and have done so. And that's very important. All too often forms come in from very senior and very expert lawyers just stating, oh, I'm a lawyer of X years experience, or I've done this case and that case. That's absolutely no use whatsoever. You must read the form, and during the form, on the form, and in the form process, and in the interview stage, you must then demonstrate those skills clearly to a panel of lawyers and lay people who probably haven't got a clue what you're talking about. So you have to be very granular about what you put in front of them and explain that in some detail. The panel will not make any assumptions about anything. It can't infer anything. If you don't give it the evidence, it can't then make a valued judgment on what you've done, and you just wasted the application, shot yourself in the foot. Secondly, at the application stage, at the first stage, at shortlisting on paper, the panel has no idea who you are. So even if it wanted to make assumptions on the papers on what you've written, it has no idea who you are, because everything is anonymous. So it's important to be as clear and precise and as detailed as you can. Furthermore, I would say that when you're filling out the application form, we see this quite often, if you're asked a question in the first box, answer that question in the box below that. If you're asked a question in the second box, answer that question in the second box. You have to be very specific. The panel cannot, certainly at shortlisting stage, look for evidence across different boxes. So if you're asked for knowledge and expertise in box A, you must give your answer in box A. If you give an answer to that in box B, which demonstrates knowledge and expertise, the people looking at the forms in the selection panel will not look at that until later. They will not look at that and carry that evidence over. So the evidence must be shown in the box for which you're making the application. Other than that, it's very important, and there was some discussion earlier on about people being coached in their answers. And at NIJAC, we have a neutral stance on that, whether that's a good thing or a bad thing, and I have a particular view about it. But just be very careful that when you come into an interview, and this may seem silly, if you're asked a question in an interview, answer the question that you've been asked. And again, all too often we find that people are coming in, they're nervous, they're a bit worked up about the interview. Someone asks them a question about knowledge and expertise, but they don't hear the precise question being asked. And then they come out with an answer that they be prepared, but it's not actually an answer to the question that was put to them in the first place. Nerves do that, overworking the whole thing and not thinking about what's happening. And I can understand, the panel understands fully that people are nervous, but you must really be very careful and listen very carefully to what you're being told. But beyond that, I've nothing else to say. I think good luck to everybody. I mean, make the application. Someone said earlier on that this is the process that some people come back and do once or twice or three times. And that's a perfectly valid thing to do. So do feel free to make the application. I would ask people if they feel that they have the skills for the role, make the application. If you're not successful this time round, come back and make the application again. Do not be put off. You can get feedback from NIJAC. You can get learning from the application process. It is a bit daunting. It's something that we lawyers don't do very often, making applications of this type. And I just stress that if you're not successful in a particular application process, do come back and reapply, because we do see candidates who do that, and we do see improved applications. And so it's a learning process in itself. But good luck to everybody, and thank you very much for listening.
Thank you very much, Michael and Bernard. I'd like to finish by thanking all of our presenters for their valuable and insightful contributions today. I hope that all those attending and those viewing the later recording of the event gain value from it. NIJAC certainly hopes to be doing more of these events in future. Unfortunately, obviously, there's been a few technical glitches with cameras today, which hopefully we will iron out. And we apologise that those took place and hope that they didn't take away from anybody's experience of the event. Thanks to all those people attending the event and showing your interest in judicial office. If you are attending to make an application for any of the judicial offices that we've talked about today, we hope that the event has been particularly valuable for you and helpful in putting your application together. And we would like to finish by wishing you all good luck with your applications.